Elon Musk's defiant stand in a tense courtroom explodes into a shocking revelation, unraveling a web of government secrets that could shake the foundations of national security. The United States District Court for the District of Columbia was a crucible of tension, its grand courtroom cloaked in silence as Chief Judge Beryl Howell swept in, her black robes trailing like a storm cloud. At 67, Howell was a titan of the federal judiciary, her silver-gray bob and piercing gaze a warning to those who dared test her resolve. She took her seat at the bench, her presence commanding absolute attention. Below her, at the defendant's table, sat Elon Musk, visionary, provocateur, and the world's richest man. In a tailored dark suit, his calm demeanor masked the high-stakes battle about to erupt. Howell removed her reading glasses, her eyes locking onto Musk with a scrutiny that could pierce steel. "Mr. Musk," she declared, her voice a blade of authority. "This court has reviewed your objections to the document production order and finds them baseless. You are ordered to produce all communications related to Starlink's satellite security protocols within 48 hours. The words landed like a gavel, each syllable heavy with consequence. "Failure to comply," she continued, her tone unyielding, "will trigger sanctions, including potential contempt charges. National security outweighs your concerns about corporate secrecy." She paused, letting the gravity of her ruling ripple through the packed courtroom, where legal observers, tech journalists, and government officials held their breath. "This court will tolerate no further delays or tactics. Your legal team's pattern of resistance suggests a deliberate effort to obstruct lawful requests." Her voice hardened, a warning that defiance would come at a steep cost. The air grew thick, government attorneys exchanging smug glances, certain their months-long crusade to extract critical documents had triumphed. But as Musk leaned forward, whispering to his lead counsel, a flicker of something, resolve, perhaps defiance, crossed his face. His attorney rose. "Your Honor, Mr. Musk has prepared a personal response he wishes to deliver, with the court's permission." Judge Howell's eyebrow arched, a rare sign of surprise. After a moment's pause, she nodded. "Very well, the court will hear from Mr. Musk directly." As Elon Musk stood, the room braced for impact, unaware that his next words would not just challenge Howell's ruling, but detonate a bombshell, exposing hidden truths that could reshape the delicate dance between private innovation and government power. What unfolded was a moment of breathtaking audacity, a revelation so seismic it left seasoned legal minds reeling and sparked a reckoning that would echo from Washington to Silicon Valley. Before we plunge into this heart-pounding clash, smash that like button, subscribe, and drop your location in the comments to join us in unpacking the legal battles shaping our future. Now, let's dive into the saga of how Elon Musk's defiance turned a routine hearing into a historic showdown that changed everything. This wasn't just a courtroom skirmish. It was a collision of titans, a battle over the soul of innovation and the limits of government reach. To understand its magnitude, we must first unravel the forces at play. Howell's unyielding judicial authority, Musk's relentless drive to protect his empire, and a case that probed the very boundaries of security and freedom in the digital age. Beryl Howell was no ordinary judge. Appointed by President Obama in 2010, she'd earned her stripes as general counsel to the Senate Judiciary Committee, honing a legal mind that brooked no nonsense. Her career was a testament to precision, her rulings in national security cases a masterclass in balancing individual rights with collective safety. With a gaze that could unravel the slickest legal maneuvers, Howell was a guardian of the law, her courtroom a fortress where truth was non-negotiable. At 67, she was a force, her reputation forged in cases that tested the intersection of technology, privacy, and power, exactly the terrain of this explosive dispute. Elon Musk, at 54, was her opposite, yet equal in stature, a man whose name was synonymous with disruption. Through Tesla, SpaceX, and his audacious rebranding of Twitter into X, he'd rewritten the rules of industries, his Starlink network beaming internet to the remotest corners of the globe, his Neuralink pushing the frontiers of human cognition. Musk was a paradox, a visionary revered by millions, yet a lightning rod for controversy, his public spats with regulators, from the SEC to the FAA, legendary. His followers saw him as a bulwark against bureaucratic overreach, a champion of innovation unbound. But to his critics, he was a rogue, his combative streak a threat to orderly governance. In this courtroom, he was neither hero nor villain, but a defendant facing a federal juggernaut, his empire's secrets at stake. The case had its roots 6 months earlier, when a coalition of federal agencies, the Department of Defense, the National Security Agency, and the Cybersecurity and Infrastructure Security Agency, demanded Musk produce Starlink's security protocol documents. They argued these were vital for a classified national security review, citing the network's critical role in global communications. Musk's legal team fought back fiercely, claiming the request was a fishing expedition, seeking proprietary secrets that went far beyond security needs. They hinted at darker motives, pointing to ties between agency officials and Starlink's rivals, suggesting a veiled attempt at industrial espionage. The dispute wasn't just about documents. It was a referendum on the balance between government oversight and private innovation, between national security and corporate autonomy. Legal scholars saw it as a landmark case, the Wall Street Journal calling it a battle over the soul of Silicon Valley, the Washington Post framing it as a defining moment for tech-government relations. The courtroom was a microcosm of these stakes, every seat filled with observers who knew the outcome could ripple across industries. Security was airtight, federal marshals stationed like sentinels, a nod to the case's gravity. As Musk rose to speak, the tension was palpable, Howell and Musk locked in a silent duel of wills. This was no ordinary proceeding. It was a crucible where the future of technology and security would be forged. "Thank you, Your Honor," Musk began, his voice steady but charged with conviction. "I'm grateful to address the court directly on a matter that transcends legal technicalities and strikes at the heart of America's innovation and security." Howell's expression remained neutral, but her slight nod signaled she was listening. "I understand this is about compliance with a lawful order," Musk continued, "but my response is directly tied to the risks of that compliance." He paused, drawing a single sheet from his jacket, the gesture deliberate. "My objection isn't just about protecting trade secrets, it's about averting a catastrophic security breach that compliance, as ordered, would create." A murmur swept the courtroom. Government attorney Catherine Reynolds shot to her feet. "Your Honor, Mr. Musk is recycling rejected arguments. Our safeguards ensure sensitive data is protected." Howell silenced her with a raised hand. "I'm familiar with your protocols, Ms. Reynolds. Continue, Mr. Musk, but be precise." Musk nodded, his gaze unwavering. "The government seeks our full security protocol documentation, including encryption keys and access mechanisms for Starlink. What this court hasn't been told is that 3 officials with access to these documents have troubling ties that raise serious counterintelligence flags." The room gasped, Reynolds leaping up again. "Your Honor, this is outrageous! Mr. Musk is slandering cleared officials with baseless claims." Howell's hand shot up, her voice sharp. "These are grave allegations, Mr. Musk. Do you have evidence?" Musk's expression was grim. "Yes, Your Honor. My security team has documented multiple instances of these officials communicating with foreign entities known for technology theft. We've compiled a confidential report for in-camera review." The atmosphere shifted, Howell's posture stiffening, a subtle sign of her heightened focus. Reynolds, visibly tense, protested. "Your Honor, we object to these smears against dedicated public servants." Howell's gaze was steely. "Ms. Reynolds, if Mr. Musk has credible evidence, this court must review it, But Mr. Musk, unsubstantiated claims will not be tolerated. Musk's voice was resolute. I understand the gravity of these accusations, Your Honor. That's why I've resisted compliance without stronger safeguards. Standard procedures are inadequate for our advanced encryption systems, which are targeted by sophisticated foreign intelligence operations. He faced the government's table, his tone measured but pointed. I'm not claiming these officials are traitors, but evidence shows they've been approached by entities seeking our technology, the very technology this court orders me to hand over. Howell's eyes narrowed. Are you suggesting compliance could endanger national security, contrary to the government's claims? Musk nodded. Precisely, Your Honor, but there's more. He hesitated, choosing his words with care. The government calls our objections obstruction, but they've withheld that we offered alternative documents sufficient for their security review without exposing our most sensitive protocols. Reynolds interjected, her composure fraying. Your Honor, those alternatives were inadequate. Musk shook his head. Not true, Ms. Reynolds. Your technical team confirmed in writing that our documents met security needs. I have their assessment here. He held up another paper, his voice rising. What changed wasn't security requirements, but the scope of information sought. Howell's expression darkened, her voice cutting through the room. Ms. Reynolds, is Mr. Musk correct that your team initially approved alternative documents? Reynolds faltered. Your Honor, preliminary discussions evolved as our review progressed. Howell's tone sharpened. That's not what I asked. Did your team provide written confirmation, as Mr. Musk claims? Reynolds, cornered, conceded. There was a preliminary assessment, Your Honor, but it was superseded. Howell removed her glasses, a gesture that signaled trouble. Mr. Musk, submit that assessment and your security evidence to my chambers. Ms. Reynolds, I expect a full explanation of why this wasn't disclosed. The courtroom buzzed, the balance shifting as Musk's revelations exposed cracks in the government's case. Musk pressed on, his voice now a blend of urgency and conviction. One final point, Your Honor. The protocols sought aren't just proprietary. They're a quantum-resistant communication breakthrough with profound national security implications, developed privately without government funds. He locked eyes with Howell. The real issue isn't compliance. It's whether the government can force a private company to surrender revolutionary technology when its own security protocols are suspect. The silence was deafening, Howell weighing his words as the case transcended legal minutiae to probe the essence of power and innovation. Howell spoke, her voice steady but grave. This hearing is continued until 9 a.m. tomorrow. Mr. Musk, deliver your evidence by 5 p.m. for in-camera review. Ms. Reynolds, provide a full accounting of the changed requirements. Court is adjourned. As she rose, the courtroom erupted in whispers, the once certain narrative shattered. What began as a routine enforcement had become a high-stakes inquisition into government transparency and security vulnerabilities, with Musk's audacity at its heart. The next morning, the courtroom was a pressure cooker, packed with onlookers drawn by the previous day's drama. Howell entered precisely at 9, her face etched with the fatigue of a sleepless night, but her resolve unshaken. I've reviewed the materials from both parties, she began, her tone somber. Significant concerns have emerged. She turned to the government's table, where Reynolds was joined by Martin Clarkson, a senior DOJ attorney, signaling the case's escalating stakes. Ms. Reynolds, Mr. Clarkson, your filings contain troubling discrepancies. Why was this court not informed that your technical team deemed Mr. Musk's alternative documents sufficient? Clarkson rose, his voice cautious. Your Honor, the initial assessment was preliminary, based on an incomplete understanding of the security architecture. Howell's gaze hardened. Mr. Clarkson, that might hold if not for emails, dated 2 months later, where your lead examiner states, The alternative documentation contains all required elements for security validation. Additional materials sought exceed security needs. She lifted a document, her voice icy. Senior officials then instructed the team to revise their assessment to justify broader demands. That revision underpinned your filing. This raises serious questions about your candor. Clarkson shifted, uneasy. Your Honor, internal deliberations involve robust discussion. The final determination reflects our judgment. Howell's response was sharp, directing experts to alter professional assessments to expand document demands without disclosure is not discussion, Mr. Clarkson. She turned to Musk. Mr. Musk, your evidence regarding certain officials' ties is credible enough for further investigation. I won't discuss specifics in open court. The room hung on her words as she issued her rulings. First, the document production order is stayed. Second, I'm appointing an independent technical special master to assess whether Mr. Musk's alternative documents suffice. Third, I'm referring the officials' ties to counterintelligence authorities. Fourth, both parties will meet in chambers post-hearing to discuss protocols. Finally, the government will show cause why sanctions shouldn't be imposed for non-disclosure. The rulings were a bombshell, government attorneys exchanging worried glances, Musk's team quietly triumphant. Howell addressed Musk directly. While your concerns are credible, this court expects full cooperation with legitimate reviews. The special master should resolve your proprietary concerns. Musk nodded. Thank you, Your Honor. We're committed to cooperation, provided our innovations are safeguarded. Howell's final words were a clarion call. This case exposes tensions between security and innovation, oversight and enterprise. Transparency is the only path forward. As she adjourned, the courtroom buzzed, a new narrative taking hold. A federal judge had validated a private citizen's challenge to government overreach, exposing flaws in the system meant to protect the nation. The fallout was immediate and far-reaching. News outlets dissected the drama, the Washington Post headlining, "Judge halts Musk order amid security scandal," the New York Times declaring, "Musk's courtroom gambit exposes intelligence gaps." Legal scholars hailed Howell's rulings as a masterstroke. Harvard's Noah Feldman wrote, Howell's nuanced approach redefines the tech security nexus, demanding accountability from both government and industry. On Capitol Hill, Senator Chuck Grassley called for oversight hearings, citing disturbing transparency failures. Senator Ron Wyden echoed, "This case demands clearer boundaries for government-tech interactions." Within the executive branch, the Director of National Intelligence ordered a counterintelligence review, with 3 officials quietly placed on leave. Attorney General Merrick Garland launched a DOJ probe into the case's handling, focusing on Reynolds' team. Tech giants rallied, the Computer and Communications Industry Association filing an amicus brief supporting the special master, arguing for independent technical oversight. Dr. Helen Cheng, the appointed special master, began her work, her reputation for impartiality a beacon in the storm. For Musk, the confrontation was a defining moment, his calculated risk revealing a strategic depth beyond his public persona. The Financial Times noted, Musk proved he can outmaneuver in court as deftly as in business, wielding evidence like a scalpel. He remained restrained, stating, "We support security cooperation while protecting American innovation. Judge Howell's ruling strikes that balance." Howell's handling drew universal praise, the American Bar Association lauding her unflinching independence. 6 weeks later, Dr. Cheng's 78-page report confirmed Musk's alternative documents met security needs, protecting his quantum-resistant breakthroughs. Howell adopted the findings, issuing a modified order that vindicated Musk while setting a precedent, the Howell Doctrine, with 3 pillars. Government must justify specific security needs, courts should use technical special masters, and private security concerns deserve serious review. The counterintelligence probe led to charges against 1 official, validating Musk's warnings and exposing systemic gaps. The case spurred legislative action with the Bipartisan Technological Innovation and Security Act codifying Howell's framework. A year later, Howell's keynote at the ABA's National Security Law Conference crystallized her philosophy. Security and innovation thrive only when balanced by transparency and constitutional rigor. Courts must ensure those boundaries serve justice, not convenience. For those in her courtroom, her words were a testament to a case that redefined the tech frontier. If this saga of defiance and truth ignited your passion, like this video, subscribe and comment below. How should we balance security and innovation? Share stories of bold stands against overreach in your world. Join us for more battles shaping our world, and let's champion A together. Future where justice triumphs.